This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we're speaking about a man bites dog story where the dog bites back, and the Third Circuit Court of Appeal compels arbitration of IFPA qui tam claims. Government Employees Insurance Company, GEICO, sued dozens of healthcare providers in a case brought in the United States Court of Appeals for the Third Circuit, decided on April 15, 2024. The Third Circuit required arbitration of GEICO's claims of fraud by healthcare providers under the New Jersey Insurance Frauds Prevention Act. The IFPA allows insurers to sue healthcare providers pursuing insurers with assignments of benefits from personal injury protection claims, no-fault insurance, on behalf of the state. GEICO did so against multiple healthcare providers who asked the court to compel GEICO to arbitrate each potential fraud claim. GEICO sued the defendants, collectively the practices, in separate actions in the District of New Jersey, alleging they defrauded GEICO of more than $10 million by abusing the personal injury protection benefits offered by its auto policies. It alleged the practices filed exaggerated claims for medical services, sometimes for treatments that were never provided, billed medically unnecessary care, and engaged in illegal kickback schemes. GEICO's suits against the practices each included a claim under the IFPA, which gives insurers a fraud claim. The medical practices sought arbitration of GEICO's IFPA claims, arguing both that a valid arbitration agreement covered the claim and that a different New Jersey insurance law allowed them to compel arbitration. But each district court disagreed, ruling instead that IFPA claims cannot be arbitrated. The Third Circuit, however, concluded that they can be, and that the practice's effort to compel arbitration under a different New Jersey law could do the same for the practice's FAA, that's the Federal Arbitration Act, based request. GEICO bears the burden of persuading the Third Circuit that the IFPA prohibits arbitration. GEICO claimed that every known decision has held IFPA claims inarbitrable. The practices cite no case holding otherwise. GEICO claimed that the IFPA's anti-fraud mission bars arbitration, but it does not explain why arbitrating IFPA claims frustrates that goal. The United States Supreme Court has made clear that claims arising from laws empowering private attorneys general can be arbitrated. The American Arbitration Association rules give the arbitrator broad discretion to grant any remedy or relief. In addition, New Jersey has a strong policy in favor of arbitration. The Third Circuit, therefore, predicted that the New Jersey Supreme Court would allow arbitration of IFPA claims. Having concluded that IFPA claims are arbitrable, the Third Circuit then considered whether the IFPA claims before it should be compelled to arbitrate. New Jersey insurance law, according to the Third Circuit, compels arbitration, and each practice sought arbitration of GEICO's IFPA claim through New Jersey statutes. It allows any party to compel arbitration of, quote, any dispute regarding the recovery of medical expense benefits or other benefits provided under PIP coverage arising out of the operation, ownership, maintenance, or use of an automobile. Close quote. As these suits are GEICO's effort to recover medical expense claims paid through auto insurance PIP benefits, they fall under the provision's plain text. GEICO asserted that the provision does not apply to IFPA claims because they deal with insurance fraud. First, the provision does not have an exception for fraud, and the Third Circuit may not carve a broad exclusion from a plain statute on the Third Circuit's own initiative. Second, the list of claims specifically subject to the provision suggests fraud falls under the umbrella. That group includes whether the disputed medical treatment was actually performed and whether the treatment performed is reasonable or necessary. That is, the alleged fraud underpinning GEICO's IFPA claims, billing for fictitious or unnecessary care. Because the provision's plain language is broad and does not carve out fraud, but rather explicitly includes fraud-like claims, GEICO's argument failed to persuade the Third Circuit. GEICO's IFPA claims, therefore, were found to be subject to the arbitration agreement, and in the alternative, the Third Circuit also concluded that GEICO's IFPA claims must be compelled to arbitration under the Federal Arbitration Act. That statute compels claims to arbitration once a movement shows both that an arbitration agreement was validly formed and that it covers the claims at issue. To establish an agreement was formed when, as here, a motion to compel arbitration is based on a complaint standing alone, a defendant must show that the complaint and the documents on which it relies facially suggest that the parties agreed to arbitrate. GEICO does not contest the practice's reliance on two documents to suggest formation of an arbitration agreement. The first is GEICO's pre-certification and decision point review plan. The plan, and this document, required by New Jersey law and approved by the New Jersey insurance regulator, governs GEICO's reimbursement of PIP claims. GEICO could force the practices to prove more than a suggestion by submitting or pointing to additional facts sufficient to place the arbitration agreement in issue. It would not have taken much for GEICO to put contract formation in play. To compel arbitration of GEICO's IFPA claims, the Third Circuit concluded GEICO must hold, and it must hold, that the arbitration agreement in the plan covers them. Nothing in the amended complaint precludes arbitration of GEICO's IFPA claims, and rather the law, according to the Third Circuit, requires it. Therefore, Third Circuit concluded the district court abused its discretion in denying the motion, and the Third Circuit ordered arbitration. In my opinion, since local prosecutors fail to deal with healthcare providers who try to defraud insurers like GEICO in PIP claims, GEICO used the qui tam provisions of the IFPA to sue the medical providers and thereby take the profit out of their crime. The healthcare providers compelled arbitration, thereby requiring GEICO to prove fraud in each individual claim, which will probably cost more than the amount of the fraud. What is needed is for the state to prosecute the fraud perpetrators or allow the fraud to continue, since it may become self-defeating for GEICO to go through with hundreds of individual arbitrations, regardless of the legal basis for the Third Circuit's decision. Its practical effect is to make PIP fraud profitable, and that the fraudsters could sing hosannas for the Third Circuit's decision. The criminal doctors need to be prosecuted, as the Department of Justice is prosecuting Medicare and Medicaid fraudsters. The state of New Jersey must emulate what the federal government is doing, instead of forcing insurers to try to do it themselves. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll be advised of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos. They're all free. And you'll have access to the more than 4,700 blog postings and the multiple thousands of videos. Please tell your friends and colleagues about this blog and the videos, and let them subscribe to the blog and the videos as well. And if you're interested in further detail concerning insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.